All right, we're starting. Good afternoon, ladies and gentlemen. Thank you for joining us on this lovely Saturday afternoon to discuss ethics. I'm Michael Harris, professor here at the Southern University Law Center, 1987 graduate of the Law Center. So, all right. So I have a PowerPoint presentation that I want to share with you guys on this afternoon, and we're going to take it from the beginning. All right, so Southern University Law Center, December 11th, 2021, Ethics 101. All right, legal ethics, professional responsibility. The legal profession has existed for over 2,000 years, from the Greek city-states and the Roman Empire to present-day United States. Legal advocates have played a vital and active role in the formulation and administration of laws. Because of their role in society and their close involvement in the administration of law, lawyers are subject to special standards, regulations, and liability, sometimes called legal ethics, sometimes called professional responsibility. The topic is perhaps most comprehensively described as the laws governing lawyers. So ethics. Legal ethics is a term used to describe a code of conduct governing proper professional behavior, which establishes the nature of obligations owed to individuals and to society. In order to maintain a license to practice law, attorneys agree to uphold the rules of professional conduct adopted by the American Bar Association, also known as the ABA, in 1983. The ABA's rules have been adopted by bar associations of all United States, U.S. states, except California, which has a similar code, but with a different format. So why are legal ethics important? Legal ethics are important in helping the lawyers to navigate the delicate balance of these interests and to work to promote the greatest good. Ethics also serve to safeguard the interests of the client being represented and to ensure they receive service without discrimination. Examples of legal ethics is the respect of a client's confidences, candor towards the tribunal, truthfulness in statements to others, and professional independence are some of the defining features of legal ethics. So ethics. So when we talk about ethics, we're talking about morals, values that we attribute to a system of beliefs that will help the individual define right from wrong or good versus bad. Ethics, general concept, could be moral values or philosophy, the discipline concerned with the morally good and bad, right and wrong. The term is applied to any system or theory of moral values or principles. We get back to legal ethics, the principle of conduct that members of the profession are expected to observe in the practice of law. These principles are an outgrowth of the development of the legal profession. A lot of times we get the terms, they're interchangeable in terms of when we talk about ethics and professionalism. So professionalism is a commitment to serving others. The training and licensing of lawyers is intended to promote the delivery of high quality services, to expand the opportunity for people to have access to justice, and to foster support throughout society for the rule of law. The law. The legal profession has existed for over 2,000 years, from the Greek city-states and Roman Empire to present-day United States. Legal advocates have played a vital and active role in the formulation and administration of laws because of their role in society and their close involvement in the administration of laws. Lawyers are subject to a special standards, regulation, and liability, sometimes called legal ethics, sometimes professional responsibility. The topic is perhaps most comprehensively described as the law governing lawyers. I think this may be a duplicate slide, sound like I just said that. Okay, so the origins of professional responsibility in the United States. The U.S. Constitution was an important source of the eventual formulation of the ethics code for lawyers and judges. Article 3 of the Constitution contains substantive rules relating to the law and the courts, and it establishes the judiciary as an independent government power designed to check the executive and legislative branches. In addition, many of the constitutional amendments address specific legal processes. Professional associations and ethical codes for lawyers and judges began to appear in the United States in the early 1800s. States formed bar associations in the early 1800s to organize and facilitate the legal profession. The state bar associations influenced the U.S. legal system in a variety of ways and exerted control over its important players by regulating the public and private conduct of lawyers and judges. Why do I say this? Is that you have to become a student of history. If not, history will repeat itself. When I had this class, I had this class 35, 36 years ago, professional responsibility, 2L, just taking the class, had no idea what it meant. Many of us today still don't know what it means, okay? We don't come into many contact unless we get that unfortunate certified letter from the Louisiana Attorney Disciplinary Board, and then we're all nervous, okay? All right. So when the U.S. war ended in 1865, lawyers flooded the southern states to take part in Reconstruction. The questionable ethics and aggressiveness of some of these lawyers caused Southern legislators to call for the regulation of lawyers. In 1887, the Alabama Bar Association adopted the first comprehensive code of ethics. Other states followed suit. The ABA was formed in Sarasota, New York on August 21st, 1878 by a group of 289 lawyers. For many years, the ABA examined and debated the various state codes of ethics, and in 1908 adopted and promoted the Canons of Professional Ethics. For those of you all who are old enough, is that you remember there was no ABA model rules. We started off with the 32 canons. I happened to be in that hybrid transition class in terms of we had to learn both as we transitioned from the 32 canons over to the ABA model rules back in 85. So the 13 canons were intended to be a model rules that states could adapt as regulations of legal conduct. Courts or legislatures in most states adopted the first set of standards. However, legal professionals criticized the canons as being incoherent and incomplete, and the ABA replaced them in 1969 with the Model Code of Professional Responsibility. Okay, so prior to 1983, lawyers' ethics were governed largely by vaguely worded set of platitudes that hadn't changed much in 80 plus years. Ethics, if taught at all, was an elective class in law school. Lawyers were under no professional obligation to brush up on the subject, and the law governing lawyers was still in its infancy. So what prompted the adoption of the 1983 ABA model rules? What you said something? Oh, okay, I thought you, okay. So here's your history lesson. Watergate. From a third-rate burglary, the ABA model rules of professional conduct emerged. It's a photo of the Watergate Hotel. And ladies and gentlemen, let me say, I do not profess to be or proclaim to be the subject matter expert, but when I started doing these seminars on this, I started doing my research, and it was just very interesting in terms of what prompted where we are. Like I said, you have to become a student of history. All right, so in October 1972, John Dean, former White House counsel, pled guilty to obstruction of justice and served 4 months in federal prison. He spent much of his time testifying in trials of other lawyers charged with Watergate-related crimes. Of the 69 people ultimately implicated in the scandal, 48 of them who were eventually convicted of crimes, Dean has noted that 21 of them were lawyers, including Nixon himself, former President Richard Nixon. Okay, along with 2 attorney generals, 2 White House counsel, an assistant attorney general, and more than a dozen other high-level members of his administration. So is this 1972 or are we talking about 2021? It's very, very eerie. So you have to become a student of history. History will repeat itself, okay? All right, yeah. So Richard Nixon boards a helicopter outside the White House a day after resigning, AP photo. However, the sight of so many lawyers shamed so publicly provoked an outcry and even calls for federal regulation of the legal profession, which the organized bar and law schools responded in several ways. So I guess that's why we're the brunt of so many bad lawyer jokes. Okay. So following the White House scandal, which involved questionable behavior by a number of lawyers, the ABA mandated that all American law schools incorporate a required course on this topic. This is typically offered as an upper level course, most often taken in the second year. Professional responsibility courses include matters pertaining to the basic legal ethics, as well as bar admissions, legal advertising, disbarment proceedings, ineffective assistance of counsel, and judicial misconduct. The training received in law school, however, may not have sufficiently prepared lawyers, particularly young lawyers, for the ethical and related business challenges encountered in a solo or small firm practice. This leaves young lawyers in these practice environments more vulnerable to disciplinary complaints. Although rewarding, having your own law practice can expose you to certain hazards. I had the opportunity to serve as a hearing committee member with the Louisiana Attorney Disciplinary Board from 1999 up until about 2008. The appointments are actually for maximum of 2 3-year appointments, but I was working on a case, a matter that lingered on. So my tenure stretched a little bit longer than my initial 6 years. Okay, but statistics say for those young lawyers who may be with us on today, is that if you can come out of your first 3 to 5 years unscathed, you're going to be okay. Most mistakes happen between the first 3 to 5. Not saying that those of us who've been practicing 15, 20, 25, 30 years is that we are immune. So you just have to dot your I's and cross your T's. They can't. Oh, what happened? My picture. Oh, they couldn't see it? Oh, I wonder why it should have been on the PowerPoint. Okay, excuse me. Make sure. Okay. Okay. All right. So professional responsibility is the area of legal practice that encompasses the duties of attorney to act with professional manners, in a professional manner, obey the law, avoid conflicts of interest, and put the interests of the clients ahead of their own. Legal and moral duty of a professional to apply his or her knowledge in ways that benefit his or her client and the wider society without causing any injury to either. Attorneys who violate professional responsibility rules may be subject to sanctions ranging from reprimands to temporary suspension to permanent disbarment. The responsibility is defined as a charge assigned to a unique actor to signify its accountabilities concerning a unique business task. So following the Watergate scandal, which involved questionable behavior by a number of lawyers, ABA, no. Oh, so they couldn't see this picture? Oh, okay. So following the Watergate, professional responsibility, what is going on with it? Okay, let's see. Previous, make sure. Okay, all right. So available on the Louisiana State Bar Association website, there is the LSBA Practice Aid Guide Kit. And I wanted to emphasize a touch on Section 8, which talks about ethics and professionalism, which states, these are not my words, this is coming from the Bar Association, most lawyers are ethical. Most lawyers strive to be professional. However, lawyers are human. They make mistakes. They do occasionally fall short of both professional and ethical standards. Very generally, ethics is what lawyers absolutely are required to do. Professionalism is what wise lawyers choose to do. A lawyer can be strictly ethical and still fall short of professionalism. A good lawyer always strives for both. Adherence to the rules of professional conduct and the code of professionalism will allow a lawyer to practice safely, successfully, and honorably. However, there's always the possibility that a complaint can be filed against an attorney, though legitimate or illegitimate. Okay, so examinations. Every state in the United States tests prospective lawyers on their knowledge of professional responsibility. 47 states and the District of Columbia require bar applicants to pass an examination called the Multi-State Professional Responsibility Exam, the MPRE. The remaining 3 states test professional responsibility on their local bar exams. Most states have only minor variations from the model rules, if any. Regulation. State bar associations, their functions differ from state to state, but often include administration of a state bar exam for admission of attorneys to practice law, regulation of continuing legal education, and other requirements. Collecting and monitoring of an attorney-client trust accounts, collection of fees, and the discipline of attorneys for ethical or other violations. So, what types of bar associations do we have? We have mandatory, integrated, unified, and voluntary bar associations. Okay. Some states require membership in a regulatory agency, often called state bar associations, in order to permit them to practice law in the state. Such organization is called a mandatory, integrated, or unified bar. That is what currently exists in Louisiana. There is currently pending litigation is where the structure of our mandatory participation in the Louisiana State Bar Association is being challenged. Don't know what the current status is, but there is active litigation challenging our mandatory membership in the Louisiana State Bar Association. Okay, so a voluntary bar association are private organizations of lawyers and other legal professionals. These organizations focus on issues including social, educational, and lobbying functions. In the United States, 32 of the 50 states have mandatory membership in bar associations. The District of Columbia, the U.S. Virgin Islands, Guam, and the Northern Mariana Islands also have unified bar associations. So, some of the ethical concerns, as I call them, is that from my time on the Disparity Board as a hearing committee member and just from scanning through the bar journal, which I don't like going to that back section looking at these little snippets, but when you look at them, you will find some commonalities. Okay, conflicts of interest occurs when the same lawyer or firm is representing both sides in a lawsuit or previously represented one side. In countries with an adversarial system of justice, a conflict of interest violates the right of each client to the undivided, zealous loyalty of his lawyer. Conflicts may also occur if the lawyer's, ability to represent a client is materially limited by the lawyer's loyalty to another client, a personal relationship, or other reasons. 2, incompetent representation. Attorneys have a duty to provide competent representation, and the failure to observe deadlines or conduct thorough research is considered a breach of ethics. Mishandling of clients' monies. Clients often advance money to lawyers for a variety of reasons. The money must be kept in a special trust account until it is actually earned by a lawyer or spent on court fees or other expenses. When you talk to some of these young lawyers, you ask them about their IOTA account, and they act like they think if you cursed them out. They don't know what an IOTA account is. You have to have an IOTA account, a trust account. You cannot run client funds through your business operating account or your office expense account. Okay. 4, fee splitting arrangements. Attorneys may not split fees with non-attorneys or with other attorneys who have not worked on a matter for which the client is represented. All right. So you get your golden parachute case. And I'm going to take it to Mr. Baptiste. He's the subject matter expert. Maynard takes the case, does all the work, case settles before we go to trial, or he goes to trial and he gets that $100 million judgment. Boy, we got a 40% contingency on this deal, and I'm looking to break bread with Mr. Baptiste. And he said, well, Mike, you really didn't do anything but bring the client. And I say that is because I had a case like that years ago where we represented another lawyer who had one of those golden parachute cases in the beginning of his practice. And we had to sue the lawyer in federal court. The lawyer was, I will not call his name, but he was a big high-powered lawyer out of Florida, the $1 Million Man. and did the research on it. And the rules say quantum merit, you have to do some work. You just can't babysit or hold a client's hand, okay? It's unethical to split fees when you're not working, you haven't provided or done anything on the case, okay? All right, disclosure of 5, disclosure of confidential information. Lawyers are under a strict duty of confidentiality to keep information received in the course of their representations secret. Absent law to the contrary, lawyers may not reveal or use this information to the detriment of their clients. Pay attention to number 5 because you will see how important it is as we get into a couple of slides coming down the road. But also, I tell people all the time is that when you're out socially and you're discussing legal matters or whatever, you never know who's listening. So be careful in terms of the environment or the venue where you're discussing client information or legal tactics or whatever, because sometimes the walls do have ears. Yeah, and smartphones. Okay. Okay. Communication with represented parties. An attorney may not communicate directly with a person who they know to be represented by counsel with respect to a matter for which the attorney is seeking to communicate. For example, in a civil suit, the plaintiff's attorney may not speak to the defendant directly if the attorney knows that the defendant is represented by counsel without their counsel's express consent. 7, proper solicitation and advertising. Attorneys generally may solicit business by personally offering their services to potential clients who are not already close friends or families. Advertising by attorneys is also strictly regulated to prevent puffery and other misleading assertions regarding potential results. So I don't have any billboards, never had billboards, never had commercials or anything. So if you're deciding to have your radio, TV, billboard ad or so forth, I would suggest that you check with the Bar Association and to get prior approval before you disseminate that electronic advertisement, is to make sure is that your advertisement is in compliance with the regulations. Oops. All right. So this is the one I wanted to talk to you about. The new kid on the block. This is the Joker. And we all know about the Joker, right? Well, if anybody knows, if you watch Batman. Okay. Right. Uh-oh, why is it? I'm going to do it this way. All right. All right. So the new kid on the block, as I call him, the Joker. Long before social distancing entered the world, video conferencing platforms touted its capability for lawyers. These products are being used on a scale of proportion that's unprecedented, and potentially before lawyers' companies are ready for them. Attorneys working from home and reliance on home computers often uses the internet security that pales in comparison to the protections built into professional telecommunications. There's a greater risk of user error and phishing than cyber attacks. Lawyers may have roommates or family members sheltering in place with them who may not know or may not care about the confidentiality of conversations or documents, whether in digital or analog form. All right. So lawyers need to work within the constraints of the rules. It is easy to comply in the office, but the rules are harder to apply in a work from home environment. Video conferencing raises specific ethical concerns for attorneys. Confidentiality, of course, since it is the cornerstone of professional responsibility, but also issues of privacy and security, technical competence, and the proper supervision of junior lawyers. While there is no specific rule governing ethical obligations under the modern rules of professional responsibility, when using video conferencing, however, There are three existing rules that come into play under the ABA rules and under the rules of professional conduct as they relate to Louisiana. Rule 1.1, the duty to provide competent representation, including the use of technology. Rule 1.6, which requires attorneys to keep client information confidential. And Rule 5.1, which imposes a supervisory duty on partners and management level lawyers to ensure lawyers in the firm adhere to the rules of professional responsibility. So when you look at these three rules, you can see the quandary that you could put yourself in, or your firm or yourself working from home. We have a more sense of freedom, flexibility. I think we're probably a little bit more lax working at home than in a structured environment at work. Okay. All right. As I call it, heartburn. No lawyer sets out to be a disparity statistic. Some lawyers, however, find themselves corresponding more often with the disparity authorities than others. Solo and small firm practitioners, especially with practices in criminal, family, or personal injury law, receive the highest number of client complaint letters. Many disparate complaints could have been avoided if the lawyer had implemented strong practice management habits early in their careers or followed a common sense approach to practicing law. With today's economic challenges, many recently licensed as well as experienced lawyers have been forced to reevaluate their career paths and are going solo or practicing in a small firm setting. So if you ever receive one of those nice certified letters from the Louisiana Attorney Disparity Board, you're going to be nervous. But you're going to be even more nervous if you fail to respond within the 15 days. Okay. If you do not respond within the 15 days, is that the allegations within the four corners of that piece of paper, they are deemed as admitted. Okay. So just think about it from your civil procedure days. That's a request for admission of fact. If you fail to answer, it's deemed as admitted. So do not ignore it. Yeah, you ask for an extension. Okay. Yeah, but they still, even though here it is that they still have to do their due diligence and look into it. Because I'll tell you this, when I started off as a hearing committee member, I think which one go? You have tier 1, tier 2. I think for the first 2 years, what happened was before the ODC can bring formal charges, they will submit all the allegations and they have to get authority. So it come to me is that there's not enough here. So we either say stop or go. So they just don't have it. But once they get authority to proceed forward, that's a done deal. So I mean, it is a review. They try to weed it out. Okay. And a lot of times is that it's the public perception. We have to have this transparency with the public that we serve for the greater good of society. And as I always say, is that if law enforcement was held to the same standards as we are as lawyers, I don't think we would have the bevy of problems in the law enforcement system that we currently have. Yeah. Okay.
Yesterday, the issue came up as to whether or not if a lawyer faxed over some information, and in the information also faxed over his entire should you ethically be to call him and say what he did and not look at it, send it back to him and trend it?
Well, I don't know how it is. I know on the back of on my email sheet and on my fact sheet is that there's a little disclaimer. If any information in this document was inadvertently sent to you, please contact the senator. I mean, yeah, I think the lawyer who may have received it in error has an ethical obligation to notify opposing counsel.
We got to that part, but the issue came about was whether or not we should read it.
Oh well.
Ethically, should
What?
we read it?
Well, I would probably say the ODC's answer is no. But the question is, it's probably not until you started reading, you didn't know what it was. That's what I'm saying. I don't even know anything about. I'm just saying, as a human being, it's like I'm starting to read. I'm like, well, why did he send me all his strategy? I said, oh man, he made a boo boo. Yeah.
Okay.
So what did it say?
No, that was the question that was hypothetical yesterday. I agree with what you said, but I said I'm going to read it. Yeah, some other people said, well, I wouldn't read it.
Well, I put it this way: is that okay? So you have a duty to contact your opponent, say, hey, you made a mistake and sent that to me. Your opponent should feel real bad is because when we said what was that one point about being up to date with technology, because that is now they have a problem. Yeah. Right. Okay. Well, listen. Yes, ma'am.
I've never heard of, I'm in Alabama. They're like, there's nothing they really have. And I did a study.
Right, it's disproportionate to your the membership, and I don't have the numbers here, but I would if I was a betting man, I would say the same thing exists here in Louisiana. I don't have the legal answer, but I think is that now we're getting into a societal question. Is it because is that what we're talking about? We should talk about in terms of the reflection or the disproportionate amount of discipline with minority lawyers in Alabama, Louisiana, California. Whatever. To me, it's a microcosm of society. So it's just not within this profession; it's in society. So how do we deal with it? I heard you guys over lunch. we have to change society. I mean, because if not, is that this type of uneven hand discipline or whatever is that it's the same thing that exists in society in my mind.
I can say about the weekend cases prior to 2000.
When you want to know what the difference is, you want to tell you what the difference is. The difference is what was it? Was it 2001? No, it wasn't 2001. What I forgot what year it was. It was that when the ODC was created. Okay.
Yeah, it really changed.
Yeah, it so my question is in Alabama. So my question is in Alabama is what it sounds like is the Alabama Bar Association does not have huh? No, I was gonna say is that they don't have an arm like the ODC. They're handling everything because the Louisiana State Bar used to handle everything until they created the Office of Disparate Counsel. So I guess your disparate arm in Alabama is in the Bar Association. Okay, so really the state bar here is really it's more administrative. And ODC has the authority. Those are the ones that you're, yeah. But I will tell you this. I think now here ODC has there's a breakdown. They talk about male, female, age, black, white, other, categorized in terms of what type. Yeah, you could kind of see is that where the land might what does everybody keep stepping in or stepping on.
See, there's another thing that it is just recently came up, suspension of the local lawyer for under that, 8 years. It seems as though found somebody who may have found something.
Well, I would tell you this much is what I think the first change to be fair is that just like it's an open book when it go for lawyers discipline, I think the book or the onion needs to be peeled back on judicial discipline also, because the judges, we have no idea what he or she is. Yeah, but I'm just saying, yeah. Because what? In order to be a judge, you had to be a lawyer in good standing. So I mean, so the rules of the game should be the same for all. All right. So listen, I only have a little bit. Yeah. Okay. All right. So listen. So ABA Model Rule 8.4, misconduct, maintaining the integrity of the profession. It is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or doing so through the acts of another. B, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. C, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. D, engage in conduct that is prejudicial to the administration of justice. E, state or imply an ability to influence improperly a governmental agency or official, or to achieve results by means that violate the rules of professional conduct or other law. F, knowingly assist a judge or judicial officer in conduct that is in violation of applicable rules of the judicial conduct or other law. And E, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or social economic status in conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from the representation in accordance with Rule 1.16. This paragraph does not preclude legitimate advice or advocacy consistent with these rules. And that's the ABA. So what does Louisiana have? 8.4 misconduct, maintaining the integrity of the profession. Pretty much mirrors the ABA model rules. So what's the difference? All right. ABA model rule of professional conduct 8.4b, commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Louisiana's 8.4b casts a wider net by branding as misconduct any criminal act by a lawyer, irrespective of whether it casts doubt on the lawyer's honesty, trustworthiness, or fitness to practice. So, yeah, you Peyton Murphy about the wellness check. Yeah. So hold on, let me finish one. So commit a criminal act. Here's a distinction between ABA and Louisiana. 2 words, especially one that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Getting back to, you said the criminal aspect of it? Okay, that's the criminal aspect of it. Still got to deal with the ODC. I'm sure that I don't think so. No, because what did it say? It matters not, ladies and gentlemen, I'll tell you this. Yeah. The issue is, it's not on that. It's not on your life. Is that if you are arrested, okay? All right. So if you're arrested, so hold up. If you have you previewed my PowerPoint? Because I'm getting ready to cross that bridge. If I could get there. Okay. So no. So what I wanted to say is, just remember this, ladies and gentlemen. Lawyers are human. We make mistakes. Okay. As my parents used to tell me, they said, what you do in the dark will come to the light. It may not be today or tomorrow, but it's when you least likely expect it. If you do something, I think under 8.3, also you have a duty to self-report. So get ahead of it, not behind it. Okay. All right. So tips to avoid disciplinary procedure. 1, implement strong law office practice procedures, client screening, your retainer agreements or letters of engagement, as if you may want to call it, client and third-party funds. I tell people, I don't care if you're selling Girl Scout cookies, Krispy Kreme donuts, popsicles, snowballs. If it's somebody else's money, do not touch it if it does not belong to you. Communication, diligence, and honesty, client confidentiality, social media and the internet, conflicts of interest, professional and personal decorum, emotions, look before you leap, stay abreast with the law, your recent developments. And Professor Reed and I were talking, and the 5 Ps. I know Maynard knows that the 5 Ps. Proper preparation prevents poor performance. Come on, Sin. You didn't know that one either? Yeah. Okay. So here we go. I'm getting ready to cross that bridge where you wanted to go, Baron. Okay. So as I call it, above the law, the collision. I had a civil trial with this young man about 3 years ago. Many times lawyers who get themselves caught up with the Bar Association, LDC, a lot of times it has nothing to do with the practice of law. Nothing. Ladies and gentlemen, you have to realize is that in this profession is every minute of the day that we wake up and sleep or whatever we do is governed by the rules of professional conduct. Okay. This gentleman here was licensed in Louisiana and Texas, got into a domestic altercation with his girlfriend, beat her up, dragged her, fractured her eye, her orbital bone, and so forth. He is currently practicing law, at the Louisiana Department of Corrections for the next, I'm just, yeah, yeah, okay. So here's a young man, did the 7 years of schooling, Louisiana, Texas, down the toilet. Yeah. All right. Here's the gentleman, this is the one you were referring to about who's bringing the contraband into the West Baton Rouge Parish Prison. Not this one. Michael Fontenot, 71 years old, accused of coordinating with West Baton Rouge Parish work release inmate to bring an opioid into the jail in March. I think this was last year. Okay. So listen, sometimes as lawyers, as smart as we are, we make dumb choices. Okay. All right. Then we get into a point is that we've had a successful legal career and we turn it into politics, and we use our influence as a not only as an attorney, but as a politician. And former Senator Shepherd got himself in trouble with money laundering. Now, this is one I was talking to because my sister is in Texas and she shared this one, but this is what I wanted to tell you all, ladies, and when we start talking about these video platforms, okay? So there, lawyers say Dallas judge has staff members pretend to be her online during a court proceeding. A group of defense lawyers have accused the Dallas judge of ordering her court coordinator to pretend to be her on an online proceeding. The Dallas County Defense Lawyers Association filed a complaint last week with the State Commission on Judicial Conduct, alleging that State Judge Amber Givens' coordinator illegally acted as the judge in a hearing to consider a suspect's bail and condition for release. Okay. So, ladies and gentlemen, as we talk about, as we get in this video world with Zoom, we who teach the law have the same issue sometimes in terms of whether or not our students are actively engaged when their cameras are not on. I can see your name, but I have no idea who's on the other side in the cloud, who's sitting there. Okay. So this video conferencing platform, Amber Givens, I don't think so. All right. Then we get into, this is another this attorney out of Miami turned out to be wanted to become a serial bank robber. Yeah, lawyer. Okay. This is in Miami. Yeah. Now this one what kind of said the judge at his bachelor party out with his buddies, had a few too many, decides to use his hand to touch the buttocks of an employee, which was a no-no. So I told you, lawyers and judges make dumb decisions too. Conduct unbecoming. Oh, I don't know if it was a disparity or not. You know, all that's confident. I'm just saying this is all in the paper. Now, whether or not the ODC got into it, I don't know. They probably did because they probably did get into it because he's a city court judge, but he also maintains a private practice. So it's one of those situations is that he's a judge, but he can still have a practice. So besides ODC, I guess the judiciary may have gotten involved in it too. Yeah. All right. This disgraced judge sentenced to 14 years in prison for fondling teens, using his teenage daughter to have her little friends come over to the house, and he made sexual advances. All right. Former Judge Alan Green, 51 months in federal prison for taking bribes. Operation Wrinkle Robe. Yeah. He and his buddy, former Judge Ronald Botenheimer of New Orleans, convicted of various federal charges resulting after a 6-year FBI investigation into corruption at the 24th JDC, located in Jefferson Parish, where Botenheimer presided as judge, revealed that a bail bond with Louis Marcotte had provided meals, trips, and other gifts to the judge in exchange for law and bond requirements. Investigation, Operation Wrinkle Road, resulted in 17 convictions, including Boltonheimer, Mardicott, fellow Judge Alan Green, and several Jefferson Parish Sheriff deputies. But the interesting thing is, let me see if it's according to the November 2002 FBI affidavit, Jefferson Parish District Court Judge Ronald Boltonheimer issued rulable favorings to wealthy restaurateur Al Copeland, Popeye's Chicken, okay, in a child custody case in the expectation that Copeland would purchase seafood for his restaurant chain from the Venetian Islands marina that Boltonheimer operated in eastern New Orleans. The relationship would have gone unnoticed had it not been for Boltonheimer's earlier arrest on charge of conspiring to plant drugs in the truck of an outspoken critic of his poorly maintained shrimp dock, where a teenager had been electrocuted by a faulty conveyor mechanism. In addition, I remember the story, this happened about 20-something years ago, is that to discredit the key witness in there, he was on the wiretap. They were getting ready to plant cocaine in the young man's trunk to discredit him, and the FBI intervened. So it's really drama like television. You know, when I read it, it's like, I can't believe this is going on in real life. You know? Yeah. Okay. All right. Rudy Giuliani, lawyer, license suspended in New York, suspended for practice of law in the state due to false and misleading statements about Donald Trump's 2020 election laws. So even though we have the right of free speech, as lawyers, you have to still be careful about what you say. Okay. All right. Then we get into successful lawyers who use their wealth, influence, and power. We all know about Mr. McDermott out of South Carolina. Statewide grand jury indicted a suspended Hampton lawyer, Alec Murdoch, on 21 counts of financial crimes, alleging he stole a total of 1.3 million across 3 counties. Okay. Yeah, and the indictment also. All right. I think this is the last one. This is the one I was telling you about the other day. This young lady, my shame is real. Lawyer convicted in espionage case seeks DC bar readmission. Former U.S. government agency lawyer who was in prison on espionage charges for nearly 20 years argued before an ethics body this week that she should be readmitted to the bar to handle criminal justice matters. In a 2-day hearing in DC that ended on Wednesday, Teresa Squillicott recounted her arrest and prosecution on espionage conspiracy charges tied to a U.S. sting in the 1990s, which she handed 4 classified documents to an undercover FBI agent posing as a South African intelligence officer. Her then husband was also convicted and sentenced to prison. She was released in 2015. Now, I don't know how you feel. You could feel good, bad, and indifferent about certain people having a license to practice law or be on readmission, but I don't care. Under these circumstances, espionage, I don't care how much rehabilitation you have. That's just my personal. If we are really going to look at the integrity of this fine institution and profession, I say no. And I think there may be, is that it? Okay. Oh, wow. I got to speed it up. Okay. So coping with life and leadership, achieving a comfortable sense of work balance is always challenging for professionals. Okay. Aging parents, COVID-19, illness, just to name a few. Life is going to throw you a curveball. All right. Okay. So what's the stats? Lawyers are more prone is to abuse alcohol and other substances than the general public. We have a higher suicide rate, and alcoholism is a big part of the legal profession. So lawyers never want to admit that we have a problem, but we are human. We are no different from anyone else in society. So what? Biggest thing is what? The stress. So what? It makes us lawyers twice as likely to abuse substance than the general public. Right? So what can be done? There is a confidential and anonymous resource available to lawyers, JLAB, Judges and Lawyers Assistance Program. Or you can seek assistance or do whatever you need to do through your own health and own resources through your own private health insurance. But there is help out there if you need it. But you just have to avail yourself of the help if you need it. Only you know if you need the help. It's confidential. So I want everyone to have a safe and joyous, happy holidays. Have a safe and happy holiday season. Thank you for allowing me to speak before you on this gloomy Saturday afternoon. Okay.
Thank you, Professor Adams.
Thank you.
Yeah, he got suspended.
Oh, no, I saw it in the paper, so I saw, and I read it, but I didn't know.
Complaint was from something he
I
had
didn't know
done
they long.
as a new lawyer.
Well, maybe that's why they